The Hour of the Time may be contacted at HOTT, that's H-O-T-T, P.O. Box 940, Eagar, spelled E-A-G-A-R, in the state of Arizona, 85925. Our phone number is 928-333-2942, and our website is www.houroftetime.com.
You're listening to the Hour of the Time. I'm William Cooper.
And I'm Carolyn Nelson.
Folks, we're going to have a guest tonight who's going to, I believe, teach you a lot of things that you need to know. A lot of you who have been doubting what you've heard on this program, or on others, or from other people, are going to find out that you should have been listening a long, long time ago. Don't go away. We'll be right back. Welcome, Robert, to the Hour of the Time.
Hi, William. How are you?
Fine. Why don't you give our listeners your background, tell them who you are and what you do, and then, as we discussed earlier, teach them a few things.
Okay. Well, my name is Bob Ross, and I work with an educational organization called Boston Tea Party Enterprises, based in Sedona, Arizona. And we teach legal seminars on how to understand law, principles of statutory construction and whatnot, so that we can understand the situation we're in and know what to do about it. Our basic orientation is the Internal Revenue Service and the Internal Revenue Code, which is a great example to work with because, as you know, it's been very vulnerable. The code is just filled with really obvious deception once you understand how to define legal terms and the principles of statutory construction. The deception is really obvious, and I hope to show that tonight. I got involved in 1979 myself by just deciding one day that it didn't feel right, the whole system. It just, I felt abused, and I knew people that had been abused, and it just didn't feel right, so I stopped filing. Then for about 10 years I played around with that until 1989, during which time the IRS came after me sometimes they didn't. I fell through the cracks. But I didn't know that there was a legal position. I didn't understand the legality of it. In 1989 I got involved with Phil Marsh and Marlene Marsh, who you know, and started learning the truth about the legal aspects of it. And then in 1992 I became an associate member of their organization, which at that time was called the Pilot Connection Society, and started sharing it with my friends who had been pushing me, and I didn't want the responsibility at first, but eventually I took up the responsibility and started sharing it with friends and family, and eventually started teaching publicly and full-time.
That's the biggest hurdle to get over, isn't it, Bob, accepting the responsibility of your actions?
Oh, that's really true. A lot of people don't realize that freedom is a responsibility. It's not a gift that comes with being born in the USA. It's really a responsibility. And in fact, the courts have even ruled on this, and I don't have an exact citation right in front of me on this issue, but the courts have actually ruled that if you don't aggressively assert your rights and fight for them and learn about them, that they are deemed to have been waived. And I have lots of examples of that, which I'll be getting into this evening when we talk about jurisdiction. But just one brief one, for example, that a lot of people don't know, is that, I'll say you're driving down the highway and it's late at night, you're a little sleepy, and you just go a little bit fast, and you're not watching your speedometer, and you get pulled over. A lot of people don't realize that the minute that that police officer pulls you over to give you a citation, you are under arrest. That is actually an arrest. And you are actually within the jurisdiction of the court from that moment. And the minute that you do anything, you are giving the court jurisdiction. And that the citation is handed to you as kind of like a, if you read your state statute, you'll find out that the citation is in lieu of the arrest. That they let you go after having arrested you, giving you this citation. There are lots of little things like that that we don't know in the law that that affect us. I'll be getting more into jurisdiction a little later. But to start out with, the whole thing boils down to understanding that the way you and I talk, just conversationally, like right now, is very, very different from what words mean in the law. And there's a very important legal principle behind that. That's actually a perfectly sound principle that gets distorted by the way the words get twisted. And the reason for that is most people don't know that words are different in law than they are in conversation.
They can actually make no mean yes and yes mean no.
In fact, they can. Absolutely. That's black and white.
So you read it and you read yes, so you go ahead and do it when the meaning in the law, actually, according to the definition of that particular piece of legislation or ruling, might mean no. You could get yourself in big trouble.
That's right. They can make black mean white in a particular section of the code. And they do that a lot because they know that you think that black means black, so they redefine it to mean white. And this is a legal principle called substitute of phraseology. And it's a valid legal principle. And the reason it's valid when it's not abused is because conversational speaking, as you know, changes from day to day, from year to year. What's hip talk now is very different than what hip talk was when I was growing up in the 60s, as a hippie. And we said, yeah, man, and, groovy is out. Now, tubular is in, or something else.
You're younger than I thought you were. Groovy was after me.
I don't want to give away too much here, except for the secrets of the IRS. But the popular language changes. So the law is written in such a way that it stands still. It doesn't change with the vagaries of time and social stuff and stuff like that.
But we have to make the clear distinction here that one meaning of one word or phrase in one set of legislation may not mean the same in another. And if the meanings change, then the new definition must be spelled out in the legislation somewhere.
Absolutely. And there's actually encyclopedic reference works on definitions. One is called Words and Phrases. Words and Phrases is literally an Encyclopedia Britannica or larger set of volumes that takes all the definitions that have ever been defined of any word in law and sets them down on paper and tells you where that definition came from. And it usually came from a court decision.
Yeah, but I want to make sure that the listening audience knows that even though that is so, and even though that when those words and phrases are used in all the courts in the land, they have that particular meaning when used in that manner, there could be a law or legislation or a set of regulations where they have redefined the phrase or the word, and that must be outlined, and that definition must be clearly given in that body of work. It is available, but too many people make the mistake of assuming that it means one thing when it really does not.
That's absolutely right. That's covered in an area that I call statutory construction. When you understand how statutes are constructed, there's a type of definition which could be applicable just to, say, a chapter in a statute. it applies only in that chapter. For example, the definition of United States, which I want to get into anyway, in the Internal Revenue Code, Section 3121, which I just happen to have open in front of me. 3121E actually says, I got to find my glasses. That state, United States and citizen. For the purposes of this chapter, United States, the term United States, when used in a geographical sense, includes the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. And it also says state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. So what they're really doing is they're putting a substitute phraseology in there.
Right. Now, I want you to go back and read those over slowly and pronounce those names very clearly, because the people out there don't realize how they've been scammed. And I believe when you read the first set of names, it sounded like you said America in there. I know you said American Samoa. So
Okay.
Could you do that again, please?
I'll do that real slow. So Section 3121E. Now this is under the chapter, by the way, Employment Tax General Provisions. So this isn't some little obscure chapter. This is the actual general provisions for employment tax, which is a tax that most of us are under the impression we're involved with. So when it says for the purposes of this chapter, the chapter is Employment Tax General Provisions. Pretty important chapter. And the definition of state says the term state includes District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa, which are all territories of the United States. The term United States means, when used in a geographical sense, includes the Commonwealth of Puerto Rico, the Virgin Islands, Guam, and American Samoa. Slightly different definitions, but you get the point. What they've done is they've taken the generic idea of a state. A state can be anything. My kitchen could be a state if I define it as such. It's the state of, disarray or whatever it is. The state of hunger.
So when they're talking about someone in that context, in that chapter, being required to withhold money from someone's paycheck in order to withhold taxes, and they say that this is applicable to a citizen of the United States, it does not apply to a citizen of the state of Mexico or New Mexico or Canada or Illinois. Is that correct?
That's correct. It applies only to the jurisdiction as defined right here. And right here means District of Columbia and the U.S. possessions and territories. Now, the reason for that is that the federal government in the Constitution was given very clear jurisdiction over Washington, D.C., which was 10 square miles originally. They can create all the laws and regulations for Washington, D.C. that they want. They can't do that in a sovereign republic, which is also called a state in the way you and I speak. So in our speaking, we refer to states as, the sovereign republics, California, Arizona, New Mexico. But state also has a generic usage, which means France is a state.
Any political body.
Political body is a state. And what they've done is they've defined state very specifically here to mean the District of Columbia kind of state. Now we know they don't mean a sovereign state because the District of Columbia is not a sovereign state. In fact, they would like to be and have been unsuccessful at getting any legislation passed that would make them a state.
But they never define this when they go to employers and say, why aren't you withholding taxes from your employees? If they're citizens of the United States, you must withhold taxes. Is that correct?
Right. You see, because a citizen of the United States tends to be like a federal employee or somebody that actually lives in Washington, D.C. So those are the people within that jurisdiction, and the government is within its rights to collect taxes from those individuals. And it's a type of an excise tax. It gets really convoluted at this point if we jump around too much. So I don't want to jump too far afield of just making the point that the definition in the terms of the way we say United States in conversation, when we think 50 states are, united, is a different definition than the definition in the Internal Revenue Code for the chapter employment taxes, where that definition applying just to that chapter has a very limited and specific meaning. And in fact, it doesn't include the 50 states. And we know that for two reasons. One, if you read the amendments in that section, which is the historical notes, you find out that prior to 1960, that paragraph, state United States a citizen, used to include the term Hawaii, and before that the term Alaska. And they took it out right around 1960.
When they became states, they were
They
taken
became sovereign republics.
That's correct.
They had to take it out because they no longer fell within the jurisdiction of the United States, the federal United States. And also, there's another section, I think it's let me just look it up real quick here.
See how easy it is, folks? All you got to do is read the darn thing. Bah!
You just have to know what you're reading and not be fooled by the statutory construction and legal terms. See, but it's important to understand that, you know, it didn't start out to be deceptive. It's just being used deceptively. It started out as a general principle that, you know, sometimes a statute has to define things a little bit differently than the way they are defined conversationally in order to be absolutely clear. Now, used in this way, it becomes deceptive because, you know, my belief is that anybody could know, the average person would know, the average attorney certainly who is highly educated would know, that most people, when they think of the United States, they think of the 50 states. And the average person looking at this would obviously think that this term, United States, applied to them. So therein lies the deception. They didn't have to define the United States that way. They could have come up with another term that wasn't competitive in people's consciousness with the 50 states.
And that's where we part ways here, Bob, because where you don't think it was intentional, I know within my very soul that it was intentional from the very beginning.
Oh, I do think it was intentional. What wasn't intentional was the original principle that, you know, definitions in law may be different.
Oh, I see. Yes, you're right.
But this particular usage of that is a clear abuse.
Yes.
Because clearly everybody thinks the United States means America. Everybody thinks that. Is there anybody out there in the listening audience that wouldn't normally assume that the United States meant all 50 of the states?
Nobody but you and I and a few other people who've studied this.
Yeah. Now, another way we know that they meant it exactly as they said is if you look in the Internal Revenue Code under Section 6103, you'll see another definition of the United States, and this is another definition that applies just to a particular chapter or a subchapter. I'll turn to 6103 here. And this indicates that they know how to do it when the 50 states are involved. Now, in this case, they're talking about the confidentiality of returns. Now, returns are confidential wherever you happen to be, as far as the law is concerned in the Internal Revenue Code. If you're on Mars, these returns are still confidential. So they can rightfully include in this section a definition that is broader than the specific jurisdiction of the federal government. And in this section, the term state is defined, 6103B5. The term state means. By the way, when it says means versus includes, that has a different meaning under the law.
That's correct.
You can't, the word is and of, I mean, the state of New York is different than New York State, legally.
Yes.
An entity.
What really tripped me up when I was first beginning to study these things, and not just the Internal Revenue Code, but other particular points of law, when I came to find that when it said such and such includes Ohio, you'd take that to mean that there's a whole bunch more plus Ohio. When you really find out what it means, Ohio is the only thing it's talking about.
That's right. Includes in the law is generally a completely restricted term. It means that everything that follows and nothing more.
Yeah, pertains only to Ohio and no place else. They're really good at using words to deceive people in the law, and a lot of people out there are performing acts and doing things and paying the government money that they should never have done, been a part of, or paid.
Exactly. And you know, it gets so complicated that, you know, the IRS has an out on the includes thing. Just to make another point. 7701, which defines includes, says that includes doesn't necessarily exclude anything else. Which kind of throws another monkey wrench into the thing, doesn't it?
Well, what it means is includes has no meaning whatsoever.
Until you read the Code of Federal Regulations, which enforce the statutes.
Right.
Which is yet another thing which we'll get into a little later in terms of legal principles. Because, you know, statutes have no force of law unless they have accompanying regulations that give them the force of law.
That's correct.
So the law is actually the statute plus the regulations, and the courts have ruled clearly on that a statute that doesn't have regulations is not a law. And a regulation that doesn't have a statute also, of course, is not a law. So just to get back real quickly to the term state as defined in 6103, miscellaneous provisions, confidentiality of returns, the term state means any of the 50 states, comma, the District of Columbia, comma, the Commonwealth of Puerto Rico, the Virgin Islands, the Canal Zone, Guam, American Samoa, and the Commonwealth of North and Mariana Islands, and Mars. So they can throw in the 50 United States there, you see, because it doesn't matter to them. They can be generous. They can let returns be confidential anywhere. So it shows that they know how to do it. Now, just in case anybody thinks it's an accident, that they just accidentally left out United States in 3121, and they put it in here now because they didn't forget that, it's not an accident. These guys don't have accents. They agonize over every single word that goes in here. There's an office of the chief counsel of the IRS that does most of the research and writing on these things.
Even punctuation and capital letters are agonized over.
Everything. A capital letter S on the word state changes the meaning from a sovereign state to a federal state, and it differs whether it's in state law or federal law. The capital S reverses its meaning in state law. So you have to watch these things very carefully. The word or, there are at least 6 definitions of the word or, and a comma before the or rather a comma after the or, changes its meaning. The word or can mean end. As an example, suppose I have on my desk here a cup and a plate, a cup of tea, and a plate with a piece of pizza on it that I didn't finish because I had to call you, and a spoon. Now, I could say that I have a cup of tea or a plate with pizza or a spoon on the desk. That's all true. They're all on the desk. I could also lift up the spoon and say I have a cup on the desk. Then I can replace the cup with the spoon, and I say, or, comma, I have a spoon on the desk. Then I replace the spoon with the cup, and I can say, or, comma, I have a cup on the desk. The comma changes it.
That sounds trivial when we're talking about cups and spoons and forks on a desk, but when you get into whether or not you pay income tax or whether or not you're guilty of murder, these things have tremendous meaning.
Absolutely, because it changes the word or from meaning either or to meaning and. So a good example of where that takes significance would be, say, in 6001, which is one of the statutes that the IRS quotes in their Privacy Act statement in the 1048 instruction manual.
That's right, folks. It's not a movie.
You can go out to your bank and to your post office right now, or if you've already gotten one in the mail, look up your 1048 instruction manual, page 4, and you'll see several things that we'll discuss there tonight, including a statement that says 6001. I might as well actually read it. Let me open it up here, page 4.
Yeah, please do, Bob. If you don't, people will get confused.
So it says, in the second paragraph, it says Internal Revenue Code sections 6001, 6011, and 6012A say that you must file a return or statement with us for any tax for which you are liable. So 6001
says that only those who are liable have to file the form and pay the tax.
Right.
Okay.
Well,
so the key
which
phrase.
are liable. Well, I wasn't going to get into that just yet, the liability issue and the meaning of the word liable. That's yet another topic. But just to give you an example of the use of the word or, meaning and, in 6001, it says that they must give you a notice, or, I'll read it actually again to be precise. The second half of 6001, the second half of the paragraph says,
Dead air's a no-no, Bob.
Pardon?
I said dead air time's a no-no.
Oh, okay, I'll keep that in mind.
You got to talk even if it's nonsense.
I don't have this stuff all buried in my head. I have a lot of pieces of paper lying around me here, and pick them up hopefully when I find what I need quick. I did make some notes here, but some things I just have really to be accurate. I'm just going to look up and read. What it says here is, whenever in the judgment of the Secretary it is necessary, he may require any person by notice served upon such person or by regulations. Well, now there's an or without a comma. So in that case, the word or means and. It says by notice and by regulations. So you would expect that you would have to receive a notice and regulations that indicate that you're required to keep these records. In fact, that is the case. And if you study the regulations, you'll see that they're supposed to send you a notice that you have to keep records.
And what happens when a citizen tries to get a set of the Internal Revenue Service regulations?
Well, those can be gotten without, you can buy the regulations as in books. They cost, about $100 for the 6th volume.
Well, I know you can, but if you're required to perform these regulations under the law, shouldn't the IRS service give you a copy?
Oh, well, that's another story. The IRS, of course...
That's the point I'm trying to make. They won't give them to you.
They don't give them to you, no. They won't advise you of the regulations that are...
They won't even let you look at them.
They don't even acknowledge the question.
They don't even acknowledge that they have regulations.
If you send them a question saying, and this is just my experience, there might be cases where it's different, but I'll give you an example. A friend of mine just recently received an audit, a request for an examination appointment, which was not a summons. She was out of town, and during the time she was out of town, the IRS decided that she was being non-compliant and sent her a 30-day letter disallowing all of her deductions for that time period. While she was still out of town, the 30 days ran out, and they sent her a statutory notice of deficiency, which was almost run out by the time she got back. She was gone for quite a while. And the entire procedure was completely illegal. So she wrote them back a letter after I kind of sat down with her and showed her places in the Internal Revenue Code that covered her situation. And it was clear that the only way they can do all of that is if the initial examination was required by summons. And, of course, there was no summons. It was received by ordinary mail.
So they were operating under color of law.
They were operating under color of law. So she sent them a letter saying, being very cooperative. And I told her to, stay cooperative, at least for the time being, because there was no point in being viewed as a tax protester. Just asking, well, gee, why did you guys do all this? There wasn't any summons or anything. Could you please cite the regulation and, of course, the statutes that give you the power and authority to demand an examination from me without a summons? And, of course, they ignored her, saying, well, we'll see you in tax court, which is also, of course, silly because, as most people probably don't know, but tax court doesn't have jurisdiction over employment taxes. And that's very clear in 601-102 in the Code of Federal Regulations. The Code of Federal Regulations specifically excludes employment taxes from the tax court. How many people would know that? How many people just go into tax court automatically, assuming that they're going to have their case solved, and unbeknownst to themselves are freely and voluntarily giving jurisdiction to the tax court, which wouldn't otherwise have it?
Well, I can assure you there are a lot of people out there right now feeling very, very dumb at this very moment. And but we don't want you to feel that way. We want you to learn from this so you don't have to repeat the mistakes that you've made in the past. A lot of you out there are guilty of being hoodwinked, hooked, hoaxed, scammed, and you've had your money stolen from you.
The whole thing is, that we've been asleep. And while we were asleep, somebody was kind of raiding the refrigerator. And then some. They walked out with, your living room and your, why not, you're asleep. And there's nobody to, sound the alarm. And it happened very slowly, It's like not anybody's fault that, people are asleep. It happened very slowly over time where, these powers that be doing this and, they're doing the kind of things that you've been talking about and over the last few weeks, very slowly snuck up on us. They started before the Civil War, when the Civil War was manipulated as a means to erode state autonomy and also to try and get a central bank. They failed at the central bank, but they did erode state autonomy. A lot of people don't realize that Lincoln actually signed, prior to ratification, a 13th Amendment that would have given the states the rights to have slavery if they wanted to.
Yeah, Lincoln had no intention of freeing the slaves, did not believe that freeing the slaves was right, and if they were freed, he believed that they would all have to be shipped back to Africa or the whole thing wouldn't work.
It wasn't a question of what was humanitarian or not.
That's right.
Question of state autonomy.
That's right.
And what that original 13th Amendment, which was never ratified, actually said was that the federal government cannot interfere in state affairs, period.
Correct. And the only reason that he issued the Emancipation Proclamation was to hurt the South in the war effort. He knew that that was going to cause an awful lot of trouble after that, and he believed in his own mind that the only solution was to ship the blacks back to Africa.
It also had to do with, the Bank of London, which was lending support.
Yeah. I got to break in here, Roth. It's time to take our break. Don't go away, folks. We'll be right back after this short pause. Ladies and gentlemen, as you listen to this program each night, 2 hours a night, one at 5 p.m. Pacific, another one at 9 p.m. Pacific. I'm getting confused over these time zones. You're learning that things are completely different in this world than you dreamed they were all your life. Different than you've been living your life. You had no idea that what you're hearing on the hour of the time was ever a possibility in this country where we live. But now that you're beginning to understand that, and now that your eyes are beginning to open, and you're beginning to learn to think probably for the first time in your whole life on your own, and some of you, thank God, have even had your first original thought in your whole life. Some of you have been awake for a long time, maybe even before I ever came along, maybe before I even awakened. But you're beginning to understand now that we are living, standing, breathing, eating, working on a board that's full of wormholes over the top of a bottomless pit. And we've got to do something very quickly to save ourselves. And one thing you have to do is provide for your family, your loved ones, yourself. Now, things are going to continue to get worse, I can assure you. They have to get worse before they can get better. Remember the motto, Ordo ab chaos. They're in the process of creating the destruction of our society as we know it, our traditions as we know it. They're destroying our heroes. They're destroying our education system. They've already taken our Constitution and Bill of Rights away from us. We are, in fact, a vassal state of the United Nations. Our military is not acting in defense of the United States of America, but as the world police force under the United Nations. Understanding all of these things and beginning to understand how the Internal Revenue Service and the Federal Reserve banks have robbed us of almost everything. Most of you are going to find out sooner or later that whatever you have paid for with Federal Reserve notes, you do not own. You don't own. When all this occurs, when everything breaks down into a chaotic situation, if you're smart, you will have formed your resistance units, your militia units. You will be able to exert political control in your area. You will be able to keep order in your communities and your neighborhoods. And you will be able to defend yourselves. You're going to need some kind of a common currency. The only thing throughout the history of the world that has functioned in that manner and that everybody recognizes no matter who they are or where they live or what language they speak is precious metals in all its various forms. Our sponsor, Swiss America Trading, provides non-confiscatable, non-reportable hard assets that you can use in these situations to protect everything that you worked for all your life and to make sure that you and your loved ones have a roof over your head, something warm to eat in your belly, and you have an opportunity to survive. People who don't take those steps are going to find themselves in a very, very dangerous, volatile, and destructive situation. That's going to be dangerous for all of us in the future, but you can take steps to ameliorate that danger by calling 1-800-289-2646 right this moment. 1-800-289-2646. Do it right now, folks. 1-800-289-2646. And look around you at the faces of your loved ones if you cannot assure them at this moment that you have provided for the safety of your assets and their financial future. You must make this call. 1-800-289-2646. That's 1-800-289-2646. Do it now. You'll be glad that you did. You'll have a weight off your shoulders. Well, Robert, you are going to come back on the later episode of the Hour of the Time later tonight?
Yes.
Okay, so if we don't get through this hour with everything that we want to cover, you're going to cover it in the next hour. Is that correct?
Absolutely.
Wonderful.
I can go for 2 days, so it won't be too hard to cover a second hour.
Okay, go ahead, continue.
Okay, well, we were talking a little bit about how this started slowly, and I'd like to just make a few points on that and then talk a little bit about jurisdiction. Because jurisdiction is the key. How did they get jurisdiction over us, and what does jurisdiction really mean? It's the beginning of the whole thing. But before I get into that, I just want to, finish where I started before the break about the fact that it happened slowly over time and how insidious a step-by-step process this was. And much of that, of course, you've gone over in great detail the last few days. But insofar as the internal revenue and the economy is concerned, the Federal Reserve notes, which you mentioned, have no, not only have they no intrinsic value, but they're a form of insurance script, which means that everything you purchase with a Federal Reserve note belongs to the company who issued the script, which in this case is a private bank known as the Federal Reserve. Well, how did we get into that situation? After the Civil War, Lincoln, of course, didn't go for the central bank idea at all. He did get sucked into the 13th and 14th Amendments. But he didn't do the central bank. He issued greenbacks instead to finance the war, much to the chagrin of the central bankers who were trying to establish for many years here a central bank in the United States. And they periodically over time did have short-term central bank charters. But they wanted something more permanent. So in 1910, they sent a guy here named Paul Warburg, who got kind of cozy with this guy Colonel House and Wilson. You probably know the story. And in secret meetings and whatnot, they managed to put together a program called the Aldrich Act, which was a central banking act. Now, they probably knew that wasn't going to pass. This is one of the ways that they do things. You see, these guys, they own both parties. Aldrich was a Republican, I believe, who wasn't well liked among the people, because he was known to be aligned with the bankers. So they voted down the Aldrich plan, and then the other party, which I believe was the Democrats, came out a couple of years later with the Federal Reserve Act saying, well, this isn't going to be like those guys' thing. This is time we're going to do it right. The exact same plan, under a different name, under a different sponsor. They diffused people's caution by getting rid of the Aldrich plan, and then came in with the Federal Reserve Act when people weren't looking, which was something like, midnight before Christmas or something like that. They, whoever was in the House at the time got to vote on it, and they passed the Federal Reserve Act.
They just did that again with the Brady Bill.
They did it again with the Brady Bill. They do it all the time. They'll probably do it with the National Health Care Act, but don't get me started on that, because that'll make the IRS look like small potatoes, I believe. But what happened is once the Federal Reserve got control of the money, supply in this country. And of course, Thomas Jefferson and many other people warned us about that. He said if the banks ever get control of the economy of this nation, we'll see our children homeless on the streets, and that's exactly what happened. But once they got a hold of the money, they created the income tax, of course, to be able to help control the overall situation, to help pay the debt, which is the interest on the money that the Federal Reserve puts into circulation. Just very briefly, the Federal Reserve puts money into circulation at no cost to it except for the printing. And that money then becomes a debt of the Treasury of Americans to the Federal Reserve at a very high interest. And we now, of course, have, $4 trillion worth of debt if you listen to the GAO, and that is the guaranteed obligations of the United States. Plus, of course, there's all the unguaranteed obligations of the United States. Guaranteed obligations like your mortgage. It's guaranteed by the collateral of your house. But you still have phone bills to pay. You still have gas bills and electric bills. These are all unguaranteed debts, unsecured debts. And of course, the United States government has trillions of dollars worth of bills also. So when you add it all up, the debt of the United States is closer to 20 trillion than to 4 trillion. And but all that debt does a lot more, a whole lot more, very slowly, insidiously over time, like a cancer, than just make money for the bankers. Because believe it or not, I don't believe these bankers really care about the money. They've got plenty of money. These guys, and you know who they are, and people listening have heard the names before. I don't want to be a name dropper, but
what they care about is the collateral.
They care about the collateral, the real estate, which is one thing. They also care about a lot of other things that this debt allows them to do. See, the debt has all kinds of wonderful results from their point of view. For one thing, for example, and I'll get into some of the things, I didn't listen to your entire series of the last couple of weeks, but I'll mention some things that you may or may not have mentioned. A lot of people don't realize that high debt creates a national emergency.
Oh, wait, don't go into that because that's
coming up.
That's coming up, yeah.
Oh, well, suffice it to say that we've been in a state of emergency since, the 20s or 30s. And a national emergency, an actually declared emergency that hasn't gone away for 40 years. And for those people that like to look up things, just I'll let them look up Senate Report 93-549. Where you can find the state of, where they actually discuss the history of the states of emergency we've been in for 40 years, under which most of the constitutional rights of the people have been admittedly, by the Senate,
stripped.
Gone. They're gone. And of course, we filed bankruptcy way back at that time. Another thing they did back at that time, under those kind of, once they had control of the economy, is they eliminated the United States Treasury by public law. And I don't actually have a citation for that in front of me. That was around the 1920s or 30s. They just eliminated the U.S. Treasury. There is no U.S. Treasury. The Secretary of the Treasury is actually the receiver of the bankruptcy. You probably have all this in your documentation coming up.
Yes, but to short circuit this, so we can get back to what our subject is tonight, is that the goal is total control and total ownership. And that means that they will end up owning every single piece of property, not only in this country, but probably in the world. And the citizens, anyone who has a birth certificate registered with the Department of Commerce, Department of Human Resources, is then indentured to pay the debt. So they become slaves of this eventual New World Order.
That's right. It's really a means of controlling economic policy and private property. And if you study the Founding Fathers, you'll see they say things like private property is what creates freedom. Take away private property and you create slavery. And the difference between a slave state or a communist and socialist state and the free concept of our Founding Fathers was the ability to own private property, which was that I want to read you the definition of private property here in Black's Law Dictionary, 4th edition. As protected from being taken for public use is such property as belongs absolutely to the individual, and of which he has the exclusive right of disposition. And never before in history has a country been founded on that principle, private property. When you have private property, you have freedom. When you don't have private property, you have socialism. It's as simple as that. And the IRS And the significance of why I focus on the IRS is because it attacks that very principle. And significantly, of course, as you'll probably point out when you go over the bankruptcy and other material about the economy, that the IRS is currently working for the International Monetary Fund. And that's who pays the bills.
Which is a branch of the United Nations.
Right. And, they work through the United Nations Agency for International Development, and you probably have the public laws that people can reference on that, under the Division of Human Resources at the United Nations, and the Office of Personnel Management of the United Nations. And this is all in public laws, in our own laws, not just in the United Nations treaties, which is another legal issue, that treaties supersede the Constitution, and if you enter into enough treaties, you have no Constitution.
This is the consummate treason. The ultimate treason has been committed, and traitors are furthering it every day, supposedly working for our benefit. They're actually working to destroy us.
That's right. But there is still a solution, as you know. The solution is education, educating ourselves, which is a source of power, and knowing what to do about it. The law still has some effect. Basically, as you pointed out in your series, the guys that did this to us can't afford for the common man to find this out yet. They have to kind of they've done all the legal groundwork, but they have to kind of take the guns away slowly first. Even though they've already passed plenty of laws for unilateral disarmament, they can't enforce it until there's a popular opinion behind it.
Right. They're in the process of creating what they call a consensus of opinion among the populace, which will make it politically incorrect for someone to own guns, and when they see their neighbors frowning at them because they have a gun, they will eventually, the theory goes, buckle into social pressure and give up their weapons.
They did it with cigarettes, for example. Now, cigarettes, I don't smoke, and I don't think cigarettes are healthy particularly, but they've legislated and enforced a point of view where, cigarettes are no longer politically correct. If you light up, even outside someplace, people look at you,
Uh-huh.
And they'll do the same thing. It's not that hard. I don't watch a lot of TV, but I do like to watch enough to kind of see how they're programming the people so that I can watch out for it. It kind of gives me an insight into what the current plan is of these guys. Every major news show, CNN, all the news shows on ABC, NBC, and CBS, and all the morning news shows in particular are really good at this. Good Morning America and those shows. They are all talking gun control, gun control, gun control, and it's always about safety, anti-crime, violence in the streets.
It's always children that are getting killed.
Yeah, versus hunting. Nobody on any of these news shows has dared to mention the original reason in the Bill of Rights for guns.
Well, some of them I don't think really understand or know those reasons. The others have sold out.
Yeah. So, but it gets back to jurisdiction. As long as they can't afford for us to find out the truth as a nation, as a whole, we the people, the legal system still basically functions, and it's founded on the Constitution. It doesn't function well. It's complicated. It's convoluted. It's overburdened. In some cases, like in the Internal Revenue Code, it's clearly deceptive. But if you can decipher it, and if you can learn the little ins and outs, you can protect yourself and stand up for your rights on a legal level. And if you do that as a group, you become very powerful. I believe in fostering groups that study the law together, that work with each other to work on pleadings in court, to work on you can file suits against government officials that are usurping authority or exceeding their authority. But you can't do this alone. We need to do this at the group level, at the community level, and stuff like that. And the key is understanding jurisdiction. That's the beginning. What makes you a U.S. citizen versus an American citizen or a state citizen. And those are all different things. Again, understanding legal terms.
I just want to give you an idea of how long you've got. You've got about 6 minutes before we have to go into the closing of the show.
Okay. Well, with jurisdiction, you find out that what we do is we give away our jurisdiction to ignorance. You don't become a United States citizen just by birth. You become a United States citizen, which means a federal citizen a citizen of the federal United States, as we defined earlier in 3121 of the IRC. You become a U.S. citizen by, filling out an application for anything and has a little box on it that says, are you a U.S. citizen? And you check yes. Well, you just volunteered. That has legal effect. Every piece of paper in your life that you sign is a legal document. Every word in that legal document has been considered and thought over for hours and hours by attorneys. It all means something, and we just go ahead and we just sign it. How do you give away jurisdiction? You take privileges or benefits from the federal government. They can tax privileges. They can tax benefits. When you get something from somebody, you are creating a contract by default because they have a right to expect something back. That's called a consideration. So when you receive Social Security benefits, and that's the number one, the big one in our country, when you get Social Security benefits, then you've allowed the United States, the federal United States, to have jurisdiction over you because they're giving you something in return for, your taxes, your allegiance. You're following their rules, their statutes. The statutes are the terms of the contract. Tax court is similar. You go into tax court, you don't question it. A lot of very good so-called tax protesters have lost cases in tax court just because they did it in tax court instead of U.S. district court. They gave the tax court jurisdiction over something that it normally wouldn't have any jurisdiction over. And they can now say that your entire argument is frivolous, because in tax court it is frivolous. In tax court it's frivolous that there are no regulations spelling out exactly what kind of tax you're liable for, because you gave them your jurisdiction. So jurisdiction is very, very, very important, and we'll be talking some more about that in the next section.
The judge won't explain that when it's going on, but that is exactly the case.
Absolutely not. In fact,
so many people come out scratching their head and wondering what in the world happened, because what just happened is totally illegal. The truth is it's not illegal. They just didn't understand.
And you, ignorance is no excuse for the law. They're under no obligation to tell you what's going on. You go into court on something, even just a minor traffic violation, and the judge asks you, well, do you understand the charges against you? And you say yes, thinking, you know what he's talking about. You think that's what it means. No. When he says, do you understand the charges, he's asking for your jurisdiction. You've got to say, no, Your Honor, I don't fully understand the charges against me. I need to see a formal complaint.
Now, that doesn't mean to keep silent until you've talked to your attorney, because the moment you hire an attorney, you declare yourself legally incompetent, and you become a ward of an officer of the court who is pledged to uphold the court and not you.
That can actually happen. Not necessarily, though, if you handle it properly, if you know how to handle the complaint.
But most people don't. That's what I'm getting across here.
It's just a question of jurisdiction again.
Yeah.
If you don't know how to handle the jurisdictional issue, you could blow it by hiring an attorney. You could blow it by just saying that you understand the charges. A lot of people know better than to plead guilty or not guilty in the patriot community. They won't plead. But if you even say that you understand what they're talking about.
And that goes for nolo contender, too.
That's right. If you let them fingerprint you or give you a breathalyzer test if you've been stopped, in the case of people that try to drive without a license, you've given them jurisdiction. So there are a lot of little things like that that we must understand so we don't get into the area in which they have power, so that we maintain our own power. And there are ways to do that, legal ways, and you just have to understand the terms that are involved, the difference between a special appearance before the court and a general appearance before the court, for example. And whereas in a general appearance before the court, it says you must appear. The word appear is a legal word. When your citation says you must appear, that's a legal word. If you appear, it's considered a general appearance, and you've given them jurisdiction. You have to go in there and say, Your Honor, I'm appearing here on a special appearance, meaning I don't give you jurisdiction. Because I don't understand the charges against me. I need to see a formal complaint, which will really bollock them up because they don't often do formal complaints.
Not only that, but they have to have someone who makes the complaint, and usually there isn't anyone.
That's right. And it sounds complicated, ladies and gentlemen. This audience, it's not that complicated. We're throwing at you a lot of stuff very quickly to give you an idea of how convoluted it is and how the system has been twisted intentionally.
That's right. You should not go away from this program and try to apply any of this. You'll get yourselves in trouble. You should find someone, a good someone, who teaches constitutional law and who teaches these things, like Bob Ross, and learn from them. Attend classes.
There are some classes that I'm giving in the Phoenix area. Hopefully there are some people talking about getting some classes going in other areas. Right now I have classes scheduled in Phoenix in February 19th and 20th coming up, and then again in March, mid-March, and early April. And I call it what the IRS doesn't want you to know. But as you can tell, it's about a lot more than just the IRS. It's about your life, it's about your country, it's about your family. And it's about taking back your rights and understanding the law. And what I teach is an understanding of the law. I don't give you any magic bullets. I don't have any magic bullets. The only magic bullet out there is for the people to understand, learn, and educate themselves and band together to stand up for their rights.
That's right. So if you learn these things and you learn then to apply them, and all of us begin to do that, then we begin to exert some power. Instead of us being afraid and living in fear, the traitors will become afraid and live in fear.
Right. Now, should I give my phone number, or do you want people to contact you if they're interested in any of those?
No, go ahead and give your phone number.
Okay.
And you got to do it real quick because we're out of time.
You can reach me at Boston Tea Party Enterprises. The area code 602-282-5653. That's 602-282-5653.
Now, we wrote that number down, so if you didn't have time to get it, call us. You'll hear the phone number of the hour, the time at the end of the show, and I'll give it to you right now, 602-333-5174. Call Carolyn. She'll give you the number if you didn't have a chance to get it. If you live in Arizona, attend these classes. I might be there myself. Good night, folks, and God bless you all.
Good night.
The Hour of the Time may be contacted at HOTT, that's H-O-T-T, P.O. Box 940, Eager, spelled E-A-G-A-R, in the state of Arizona, 85925. Our phone number is 928-333-2942, and our website is www.hourofthetime.com.
Good evening. Welcome to the late edition of the Hour of the Time. I'm William Cooper.
And I'm Carolyn Nelson.
On the other end of the line here, folks, we have Mr. Robert Ross, who teaches people about the law. He teaches them about the Internal Revenue Service and all kinds of other things. He's going to be holding a seminar in Phoenix, Arizona. We'll talk about that a little bit later. I might even decide to go. I planned on being in Phoenix on that weekend anyway, and to meet with Linda Thompson. And since he's going to have his seminar over the weekend of the 19th and 20th, I may just attend this seminar also. I never, ever fail to learn something from everybody that I meet, folks, if I just have enough time to spend with them. I would recommend that if you live anywhere where you could get to Phoenix, Arizona for the weekend of February 19th and 20th, that you make arrangements with Bob Ross to attend his seminar, and especially if you've been ignorant of the law most of your life and you'd like to get straight and learn what's going on in the court and not be a victim. In other words, come out a winner instead of a victim. That's extremely important, ladies and gentlemen. So don't go away. We'll be right back. Make sure you have pen and paper by your side every time you listen to this program, not just tonight, folks, but every time you listen to this program. Now, we started out with Bob on the earlier program tonight, so this is a continuation. And if you missed the earlier episode of the Hour of the Time, you can order the tape from us. If you would like information on how to order tapes, call the Research Center and talk to Carolyn either tonight after the show or tomorrow sometime. The number is 602-333-5174. That's 602-333-5174. Welcome back, Bob. I believe that you left off talking about jurisdiction.
Yeah, we did. Jurisdiction, of course, is fundamental to all legal issues, whether you're talking about a tax case with the IRS, or whether you're talking about citizenship. What is the difference between a U.S. citizen and a state citizen? Or some people like to talk about non-resident aliens. Or whether you're talking about a speeding ticket.
Now, when you talk about non-resident aliens, are you talking about the benevolent space brothers? Are those little gray guys that Whitley Strieber was writing about?
That's right. Those little gray guys from Mars. None of them work for the IRS, I believe.
I think you're right.
They certainly speak Martian, which is another term I use when I'm telling people about legal terms and legal definitions. It looks like English, and the real conspiracy that the Martians have arranged is that their secret code looks like normal conversational English, but it's not. It's really Martian.
I hope you all realize that we're only joking about this stuff. I don't believe in benevolent space brothers, and neither does Bob. But you got to put a little humor in these things sometimes.
That's right. But it certainly is another language when we're talking about legal terms. And for the benefit of those listeners that weren't with us earlier, legal terms can be defined differently than the we use in our everyday conversation. And as we used an example before, that the United States, which all of us think means the 50 states, Arizona, New Mexico, Colorado, New York, all of the 50 states sound like, United States to you and me when we're talking about it. But in the Internal Revenue Code, and in fact in most of the federal statutes, the United States is defined differently, and it doesn't include Arizona. And they didn't just forget to leave it out. So that's what jurisdiction is all about. Jurisdiction is the key. How does the federal government, which the Congress limited in its jurisdiction to 10 square miles plus territories and possessions, and those 10 square miles are, of course, Washington, D.C., which, of course, listeners to your show know a lot more about than most people living there.
That's true.
How did we get under the jurisdiction of rules that were originally intended just for Washington, D.C.? So, first of all, I'll read the definition of jurisdiction in Black's Law Dictionary. I use the 4th edition. It's a little bit more complete than some of the later ones. They keep changing these dictionaries on us. And jurisdiction. The first thing it says is the word is a term of large and comprehensive import. I want you to realize the significance of that sentence. I mean, this is a law dictionary. They don't say things that aren't, that sound that significant unless they mean them. The word is a term of large and comprehensive import. Now, by the way, legal definitions like this in Black's Law Dictionary and others are derived from usually court decisions. So these definitions are a compilation of various key court decisions that have been upheld by the courts as being definitive of a particular term. So if you read down here through some other court cases, you'll see that there's some other definitions of jurisdiction. A lot of them apply to the courts. But in general, this following one is what we're talking about. And it is the authority, capacity, power, or right to act. So what gives the federal government the right to act, or the authority to act, over a state citizen? And this brings into play the fact that there's more than one United States, and that a state citizen has citizenship not only in one state. In the case of you and me, William, we're citizens of the state of Arizona. We're also American citizens, or citizens of the United States of America. And if we elect to be, if we volunteer to be, knowingly or unknowingly, if we accept the benefits from the federal government, we might also be construed to be United States citizens. Now, William, before you knew better, have you ever checked off on an application of any kind for a loan or for a driver's license or for a voter registration, a little box that said U.S. citizen?
Of course. I think probably everyone who's ever been born in this country and most people who've ever visited at one time or another have probably done that.
Well, since you were doing that under perjury, probably, there's usually a little statement that says, you're signing this under perjury. If you're lying, you can get in trouble. You just volunteered to be a U.S. citizen.
That's correct.
And a U.S. citizen is something very specific. In fact, it is so specific that even the statement about perjury is different for a U.S. citizen than for a state citizen or a citizen of the United States. And this is like, something that anybody out there can go look up. If you go look up the rules of evidence in federal rules of evidence, and this is in Title 28. I won't give a page number or anything like that because it could be different in a different version of the thing, but it's Section 1746, Title 8, 28 U.S.C. 1746, number 1. Now here's it saying, unsworn declarations on the penalty of perjury. If executed without the United States, remember the definition of the United States in 3121 IRC applies generally in most federal statutes. Includes Guam, American Samoa, U.S. Virgin Islands, places like that, and Washington, D.C. So if outside that area, it says something to the effect of, they don't have to use the exact language, but it says something like this. I declare, under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct. So they throw in there, if you're outside the United States, they throw the term United States of America in there, saying that you agree to abide by the laws of the United States of America in this perjury statement. Now, if you're within the United States, they don't have to throw an agreement to abide by the laws of the United States in there, since you're already part of that jurisdiction. So the statement that's in Section 2 reads, if executed within the United States, its territories, possessions, or commonwealths, I declare, under penalty of perjury, the foregoing to be true and correct. So the difference between the two statements, I'll repeat once again so everybody's clear, because I'm going to give you another example in a minute of how that's used, that you can go look up in a local library or a law library. If you're in the United States, you don't need, the perjury statement doesn't have to include the United States, obviously, because you're already there. If you're outside the United States, in other words, in Arizona, which is an independent republic, they have to include in the perjury statement for federal purposes that you agree to abide by the laws of the United States of America, because otherwise you would be outside that jurisdiction. Now, the proof of the fact that they're not referring to Paris or France or Canada or Mars is when you go look at some forms that use the perjury statement, some federal forms. Now, the one I have here is for the U.S. District Court. Any of you can go out to the U.S. District Court and get a form, which is using the Return of Service form, and it's the Declaration of Server. Now, in the U.S. District Court in Arizona, say, the Declaration of Server is signing the following declaration. I declare, under penalty of perjury, under the laws of the United States of America, that the foregoing information contained in the Return of Service and Statement of Service is true and correct. So now they included the laws of the United States of America. The phrase that is only included in a perjury statement that is executed outside of the United States. Now you go into your district court in any state republic, and that's what you'll get. A form that, according to Title 28 U.S.C., is intended for use without the United States, proving, in their own words, in their own forms, that you are not in the United States when you sign that form. You're in a sovereign state. Now, it sounds more complicated than it is, but it's a very clear definition of jurisdiction and the fact that there's more than one United States. In fact, in Black's Law Dictionary, there are 3 definitions of United States.
What are those, Bob?
Oh, without going to look it up in Black's, just off the top of my head, one is the sovereign entity that the rest of the world sees as the United States. For example, if you're in France and you're dealing with the United States, there's a sovereign nation, the group of us, is called the United States. It's a legal entity in international law. The second is the United States referring to the federal government, the United States that resides in Washington, D.C., as is defined in the federal statutes such as the Internal Revenue Code, Section 3121.
Actually, it's defined right in the Constitution.
In the Constitution?
In the Constitution, yes.
Yeah, I wasn't including that. I was just using Black's, which kind of combines all 3 different types of definitions.
Mm-hmm.
And the third definition, of course, is what everybody thinks the United States is, which is 50 states that got together in 1776 and said, well, it wasn't 50 back then, but said, hey, we're united. We're going to work together. And we'll create this supposedly little limited entity in Washington to run our international affairs for us. Well, it didn't work out that way, as you know. So you have to know 2 things in the law, very, very important to understand jurisdiction. One is who you are, and the other is where you are. Now, does anybody imagine that you can get anywhere in life without knowing who you are and where you are? And yet, when it comes to the law, we don't understand these very basic things. So the United States definition tells us where we are. We're in a sovereign state. Who we are becomes the next question. Are we state citizens, United States citizens, or citizens of the United States, which is 3 different things. when you actually break down the law. And what you find out is that, according to the Constitution, we are first and primary citizens of the sovereign republic or state that you live in. And for you and me, that's Arizona. Could be California or New Mexico or New York or Ohio and Idaho, any of the 50 states.
Mm-hmm.
Concurrently,
Go ahead.
Concurrently, we are states of the nation. I mean, we're citizens of the nation. We're American citizens. Another term for it. The legal term is citizens of the United States. Now, some patriots are afraid of the term citizens of the United States. They think it gives the United States definition, the United States jurisdiction. The term that actually gives the United States definition, that gives the United States jurisdiction is United States citizens.
That's correct. Let me read this clause from, excuse me, Article 1, Section 8 of the United States Constitution. The particular clause that creates this artificial government, which was in no way intended to be created by our forefathers, with the power that it has accumulated when they brought together the union of the several states for the mutual benefit and protection of all. But this particular clause, it's Article 1, Section 8, and it's several paragraphs down in Section 8, and I quote, "To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may be by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof." Basically what it says is they've created this district not exceeding 10 miles square, and all territories are property which is purchased and is a part of this, even though it's outside of it, and that Congress shall exercise exclusive legislation in all cases whatsoever over such district, meaning that whoever is subject to that jurisdiction has no constitutional rights whatsoever, has no rights except those granted to them by Congress, and it's exactly backward of the intent of the forefathers.
That's right. Within their jurisdiction, it's as if you're working for a company, and in fact, there's a corporate nature to the United States government, the federal United States, that the courts have actually ruled under certain circumstances that the United States federal government is a corporation and to be treated as, in the course, a corporation.
They've also ruled that it is a foreign nation to the United States Union of the several states and to the states themselves.
That's right. So it's as if, using the corporate analogy, as if you went into General Motors and you worked for General Motors and they had a dress code. And they say you shall wear a shirt and tie and jacket when you're working at General Motors. Well, if you want to work at General Motors, that's what you got to do. And if you want to agree to their employee manual and the terms and conditions of your employment contract, which include how much you get paid and how much they withhold and whatever, for insurance purposes or retirement or whatever, those are the rules of the game that you agreed to play by, and you have to play by them. But guess what? I don't work for General Motors. Now, I don't have to follow those rules unless I choose to. If I choose to follow General Motors dress code wherever I go in Arizona, then that's my form of insanity. But I don't have to do that unless, of course, I sign a contract with General Motors, which I don't plan on doing, or with the federal government. So there's another important section, if you're going to bring up the Constitution, that refers to this issue of jurisdiction and dual citizenship. And it's very clear that there's a dual citizenship in this section. In Section 2, Article 4, Section 2, of the Constitution, where it says, in the first sentence. The citizen of each state shall be entitled to all privileges and immunities of citizens in the several states. Can you see the dual citizenship inherent in that?
Of course.
So there's both, you have both the rights of a citizen in each state, and you have the rights of the citizens of all the states. Two different things under the law.
Mm-hmm.
Law is very clear and very precise. And when used properly without abuse, that clarity and precision helps keep things clear. When used abusively, it can be used to hide the truth, to deceive people, and the like. And in the case of the IRC, as we pointed out in the first show, it's clear that it was intended to be read by the average person, and the average person would, of course, read the definition of United States or read the use of the term United States throughout the IRC and, believe that it was referring to them. Because it says United States. Oh, that must mean me. But it doesn't. Now, how did we get to the point where the United States government, federal United States, can construe that you are within their jurisdiction? That not you, William Cooper, but those people out there who haven't taken the steps necessary to get out of that jurisdiction.
Are you asking me?
No, I guess it was a rhetorical question. I answer myself. But we give away our jurisdiction. And we talked about this a little earlier, but we give it away by ignorance. See, the courts and the federal agencies involved do not have to inform you when you give away jurisdiction. They don't have to tell you what the jurisdiction is. There's a lot of little ways you can give away jurisdiction. One of them is to sign a form that says U.S. citizen on it, a legal form that you're signing under penalty of perjury. So they have the right to construe that if you're signing under penalty of perjury, you're supposed to know the law, because ignorance is no excuse. They have the right to construe that you wouldn't sign that under penalty of perjury unless you were a U.S. citizen. So it's kind of like twisting it a little bit.
Or you were committing fraud.
Or you're committing fraud. And by the way, I got bad news for a lot of people out there. If you think if you signed a lot of stuff that says you're a U.S. citizen, you are in fact committing fraud. Unless you work for the federal government. Because federal employees can be construed to be U.S. citizens. That's okay. Your employers, all your employers with employer identification numbers, EINs, they're committing fraud if they're not federal corporations. They don't know that, but it's true. Because they're not federal employers. An EIN, if you read the code, is intended for federal employers. If you have a trust, a lot of people out there in the Patriot movement that may be listening to this show have trusts, common law trusts and irrevocable trusts of various kinds. Some of those trusts have EINs. Just for the convenience of having bank accounts and doing business, thinking that the beneficiary is protected.
Now, for those people out there who don't know what you're talking about, what do those initials mean?
EIN is an employer identification number. It's the equivalent of a Social Security number for an employer. It identifies the employer as a federal corporation, an employer of federal employees, and allows them to withhold taxes and Social Security from your paycheck if you're a wage earner. Well, those trusts and companies and stuff like that that are chartered in the state or in common law jurisdictions, if they have a federal employer's identification number, that is a fraud. And signed under penalty of perjury. So, given that the United States prefers to assume that you wouldn't commit a fraud, they get to assume that you're telling the truth, that you are within their jurisdiction. So you see, you gave it away.
I know just about 8 people just leapt right up off their couch when you told them that.
Well, to tell you the truth,
a lot of people do these things and think they're safe and secure, but they don't really understand what they did.
Exactly. I mean, it just goes, it's so pervasive that it's ridiculous. I mean, if you get arrested, if you get picked up for speeding on a traffic charge, and you go in to talk to the judge, and he asks you, and I used this example earlier, do you understand the charges against you? He didn't ask you to plead. Most people are smart enough to know that if they plead guilty or not guilty, especially patriots, that they're giving jurisdiction to the court. He just asks you, do you understand the charges? Bingo. He got you.
No, sir. I don't understand nothing.
That's right. You don't understand nothing.
I don't know nothing.
You don't plead. You don't understand anything. You don't know nothing. Ignorance is bliss as far as that's concerned. Because that buys you the time to figure out where you're at, to force the court into getting a formal complaint.
And that right there is enough usually to stop them, because usually there is no formal complaint and there is no complainant.
Very often that's true. And if there is a formal complaint...
That's always true in the case of traffic tickets.
Yeah. Oh, in the case of traffic tickets, even if there is a formal complaint, chances are it's signed by the prosecutor.
Right.
Well, the guy that should have signed it is the police officer that stopped you.
Mm-hmm.
Because from the prosecutor's point of view, anything that happens is hearsay. So the police officer gets up there on the stand, and you've asked for a formal complaint. First thing that happens is they call up the police officer, and he says, officer, would you state your name for the record? And he goes, John Smith. And you jump up and say, Your Honor, I object, I object. And the judge says, why? What's going on? He says, well, Your Honor, I read the complaint, and John Smith isn't anywhere on the complaint. He didn't sign this complaint. His evidence isn't admissible. It's hearsay. Because he's not the party to sign the complaint.
Mm-hmm.
But you can't do that if you give them a jurisdiction from the get-go.
That's right.
You have to understand who you are and where you are.
Now, for those of you who think we're taking an inordinate amount of time on the subject of jurisdiction, it is the number one utmost important thing that you're going to run into in any brush or joist or anything else with the law.
Absolutely. Because you have to know where you are and what court you're in. Most people don't even know that you could be standing in one courtroom and you could have several different jurisdictions that could pop up unbeknownst to you. You could be an admiralty jurisdiction, you could be an equity jurisdiction. The courts have multiple overlays of jurisdiction built in to the courts. You have to know which one you're talking to. A very good example of that is the difference between ministerial jurisdiction, which is for summary proceedings, such as excise tax or privileged activities or income tax, contracts, statutes. Those are all ministerial proceedings under, ministerial jurisdiction. Most people, they think they go to court, they think they're in a judicial proceeding, because we think all the courts are judicial proceedings. We don't realize there's multiple overlays of jurisdiction that are possible in any given court, depending on what the legal circumstances are, because they were all combined under the law quite a while ago in our country. They used to be like separate courts for these things.
Isn't it true that most people, when they enter a courtroom, are actually in an equity jurisdiction?
Probably in most cases, because you're dealing with ministerial summary proceedings in almost all cases.
And not only that, but the only real authority that our forefathers ever gave to the federal government was over interstate commerce.
Well, they didn't actually give even that. There was an argument over that.
Well, there was, but that's really the only authority that they ever got.
Later on,
yeah,
they fought against it. And they weren't so sure they wanted to give that much power to the federal government. That was in the 1800s. Originally,
and that's what sparked.
This was even a state issue.
That's what sparked the argument over the Federalist Papers.
Mm-hmm.
Is how much power is the government going to have?
A judicial proceeding deals only with the rights of private property, with sovereign rights, with the Constitution. Everything else is administrative or ministerial, which means it's a contract that you have with the government. Your driver's license is a contract. You agreed to sign up with it even though you didn't have to.
That's right. When they talk about civil actions, those are completely outside any of the provisions of the Constitution whatsoever.
That's right. You have civil rights and you have God-given rights.
That's correct. Civil rights are granted by the government or taken away by the government. They're really privileges, even though they call them rights. And the rights that the Constitution protects are creator-endowed rights, God-given rights which cannot be taken away.
That's right. But you can give them away, however. You can waive them. That's how they get you.
Well, there's even an argument that says you can't do that. Since they're endowed by God, man has not the authority to take them away or give them away or contract them away. Now, I don't know who would win that argument, but that is one of the arguments that I've heard and seen written about over the centuries, in fact.
So everyone has the answer to that till we all meet our maker. But in the meantime, the courts do assume that you have the right to give away your rights, even if you don't know you're doing it. A good example of that is the Fifth Amendment. Keep in mind that everything in the law is very specific. You have to know what every word means. You go into a proceeding, let's use the Internal Revenue Code, which is my bailiwick.
You know, we're talking probably about the only part of the Constitution that most people have ever even known about.
This is true. And it's amazing how many people don't know that in most cases, you know, you see a lot of things on TV, people, so I believe the Fifth Amendment. And you hear all there are whole volumes and volumes of stuff like this at state law level and at the federal law level, and they go step by step, by teeny weeny tiny little baby steps. And in every one of those steps, if you make a mistake, you can blow it. You can give somebody jurisdiction that they didn't have before you took that step. And the Fifth Amendment is a good example, because everybody, years ago used to file Fifth Amendment returns and say, I don't have to file this return because, I'm giving away information that could be used to incriminate myself. So they send in a return and they write Fifth Amendment returns on it. That was very popular in the 70s and early 80s. And a lot of those people, years later, lost their homes and went to jail. Were they wrong? Not really in principle. They were wrong procedurally. They didn't understand the full effect of the law.
They were also claiming a right that they're not due as citizens of the United States, or United States citizens.
That's true. That could be construed that way. But even for American nationals or anybody, when you fill out a return, you are admitting that you have, even if you don't fill out the return, you just send it in. The act of sending in a return or having a return is an admission that you have records. And the courts have ruled that if you admit that you have records, then that admission is itself a waiver of your rights. Just like in the driver's license case, where if you get in front of the judge and you admit that you understand what he's saying, you waive your rights to challenge the jurisdiction. In a 1040 form, the mere act of having the form sent in is an admission that you have records and that they have jurisdiction. So you waive your Fifth Amendment rights right there.
Let me explain this to our listening audience just a little bit. The reason that you lose jurisdiction when you send in a return, whether or not you fill it out or anything else, if you send that return in, you are complying with their requirements. And since you complied with their requirements, you have then admitted that they have jurisdiction to make those requirements upon you. Therefore, they have jurisdiction upon you, the whole you, for whatever their requirements in full may be. So this is something that people don't understand. I know people who were perfectly safe, had done everything right all the way down the line, couldn't be touched until they were called one day and asked to come in just to have a talk about the legal points that they were basing their case upon, and they actually went down to the IRS office and went in for the appointment and sat down at the desk and gave them jurisdiction by that action.
Exactly. I have a guy that just called me today. Somebody from the IRS sent him a case from the tax court intended to scare him off on some legal points that I've educated him about. And they covered some of the legal points I educated him about. And he was all freaked out because all these points were thrown out by the court as frivolous. And I said, of course. Can you imagine why? Can you guess why? So what is the jurisdiction of the tax court? Tax court, by the way, in 601.102, Code of Federal Regulations, that Code of Federal Regulations specifically excludes employment taxes from the tax court, and of course self-employment taxes. Well, most people wouldn't know that. Most of us, I think, we're dealing with employment taxes, don't we? We don't realize that the tax court doesn't normally have jurisdiction over employment taxes. So when you go into the tax court to argue a case on employment taxes, you're going in to play by their rules. So that poor person that went in to make those arguments went into a court that didn't acknowledge the existence of those arguments. They were a moot point in that court. Those rules that they were arguing were monopoly rules, and they were dealing with chutes and ladders or something.
It's also not a constitutional court, and that's why so many people who try to argue constitutional issues in a tax court get sent to jail for contempt of court.
Well, when they actually study the Code of Federal Regulations, the only issues that the tax court is supposed to decide are issues of how much you owe and how you should pay it. That's the only thing they're supposed to decide.
That's right, and when you get there, that's the only issue there is. Anything else that you bring up is contempt of court, or could be construed to be.
Of course, because they're not designed to do anything else except decide how much, how fast, and how high.
And that's what people don't understand. People have come to me for advice when they have been summoned to go into tax court. And my advice to them is to immediately file their motions in a United States District Court. And invariably, they won't do it. They'll go into tax court and try to do it, not realizing that the advice I gave them is the correct advice, and they can't make those arguments when they get to tax court. It's too late.
That's right. It's like, the tax court is basically an arbiter between you and the IRS. They can arbitrate the issues of how much you owe and the assessment and da-da-da-da, but they're not empowered to argue legal issues or constitutional issues. So once you accept their rules, you're accepting that the legal issues are no longer, in effect, are no longer the matter before the court, or in what they call subject matter jurisdiction. You've given all that up. You're now there just to argue how much you owe. So when you go into a situation where the judge expects you to argue how much you owe, and you say, well, Your Honor, blah, 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 Constitution, he says, wait a minute, we're not here to talk about Constitution, we're here to talk about how much you owe. He doesn't do it in those words, so you never quite figured out what hit you. But that's what's going on. So there's a lot of little nuances you have to understand who you are and where you are, and that's what jurisdiction is about. They want you to forget who you are, you see.
Now, you and I, Bob, have both studied the law, and I don't know about you, but when I first decided that I was going to stick my head into the law and find out what it really said in there, I was pretty intimidated, and I thought it was going to be some monumental, difficult task. And I found out that it's not difficult at all, but you have to pay attention to every single detail.
There's actually a phrase called black letter law. And what it really means is a fundamental principle of law, that the law is to be interpreted literally, exactly what's there, the black on white. And if you learn how to read the black letter law, you have a chance at turning the situation around in your own individual case. If you don't know how to read the black letter law, then you're at the whim of, the prosecutor or whoever else, because the court, the judge, the jury, whatever it is. They may or may not know the black letter law, but they will have more standing than you in court.
Now, there's something else we've all discovered, is that if you go into court and you demonstrate to the judge that you understand and know the law and can present a good argument with good points in law and file good briefs and good motions, that the judge, when he wouldn't help anybody else, will sometimes help you out. He'll have respect for you.
They actually like that. It makes them smile a little bit.
And they have a contempt, a blatant contempt that you can see when you walk into that court for anyone who does not understand the law.
Absolutely. And in a sense, I don't know if that's fair, because the system is basically manipulated so that we won't understand the law. I mean, some of the principles we're talking about today should be taught in high school or grammar school. The fact that they're not taught in school is evidence to me that something is going on that's not right. That somebody intentionally is deciding to not teach basic fundamental principles of law in the school. Principles that are as important to getting along in your daily life as reading and writing and arithmetic. I mean, in America, they pass between 20,000 and 200,000 laws in the United States, federal laws, in Congress every year. On a good year, it could be as high as 200,000 laws. Now, can you imagine this has been going on now for 200 years? I mean, everywhere you're turning, there's a law that's going to affect your life. And you don't know how to read the law? You don't know how to understand the definitions of the terms in the law?
I saw a good example of this. I watched 48 Hours tonight between shows, and they were talking about the E. coli infection in beef. And it was very plain that this is a danger. Anytime you eat any kind of raw meat, you're in danger of being infected by some bacteria or contracting food poisoning or something of that nature. And throughout history, everyone who has a brain knows that if you cook that food so that it is cooked all the way through done, you have obliterated that risk. That risk no longer applies. But this whole show was aimed toward the one question at the end. What steps has the federal government taken to stop this spread of E. coli infection? And what they're doing is planting in the public mind that there's going to be more control over food by the United States government.
Absolutely. Absolutely. There's, along with it, I'm sure many of your listeners are familiar with the issue about control of vitamins. And if that goes through, we're going to have to get restrictions just to get vitamin C.
That's right.
Of course, if you're not a U.S. citizen, they can't enforce that on you. But if the drugstores and health food stores and all of that don't know that, it's not going to do you much good. So we have to get out there and educate the people, educate the employers, and like that. When you take on these issues, it's a responsibility. It's not just for yourself that you're doing it. You have to inform your employer. First of all, you're not going to want it to withhold wages from you. Second of all, you want to protect your employer from the fraud that he's committing. He may not even be aware that he's committing a fraud, and or she. And if you like your job and you want to keep that job and opt out of the system and not have money withheld from your paycheck, you're going to have to educate your employer. And in the case of Fortune 500 companies and multinational companies, that ain't going to be easy necessarily. So what do you do? This is a question I think that each individual employee has to confront themselves based on their family needs and their job situation. It's not for me to say that a specific person should stand up and fight the system when they might lose their job and they have a family to feed. But we have to consider that and what all the options are at the very least and what our responsibilities are and weigh that. And to do that, we have to know who we are and where we are and what the options are. And if you don't understand legal terms, if you don't understand principles of statutory construction, it's like driving someplace without a map. Now, the IRS is counting on you to not know your way around. They're counting on the fact that you can't read the map. But even if you look at the map, you don't understand what you're looking at.
They're also counting on you to be absolutely terrified of them, and in most cases, they depend upon this terror to bend you to their will, and because of that, usually all they have to do is write a letter, and boy, you're just buckling under and glistening and whistling and playing their tune and dancing their little skip.
I'll give you a good example of that. To get back to the IRC, is Section 6331. Now, probably a lot of your listeners have liens and levies. In fact, I know they do because some of them have already called me between shows about the liens and levies they have that they're concerned about. Now, you get a lien. What you get from the IRS actually is not a lien. It's a notice of lien. And that notice of lien is filed in an alphabetical index at the county recorder's office and has no more force of law than anything else that you can file at the county recorder's office, which is just about any kind of document you want to record.
That's right. What happens is that usually the county recorder will then enter it as if it is a proper lien.
That's right. Well,
and he has, in fact, committed fraud.
He doesn't actually enter it as a proper lien. They actually do just enter it as a notice of lien. It's still a fraud, though. Why is it a fraud? Because everybody thinks it's a lien. So the notice of lien goes to the banks. goes to your employer. The employer starts withholding your wages. The bank freezes your assets. They didn't get anything other than a notice of lien. In fact, any of your listeners out there can check this out themselves, and here's how you do it. And you'll get a wonderful piece of evidence that you can use in your battle against the IRS. If you have a notice of lien on your record, if you receive notice of lien, for most people it would be more than 10 days have passed, so the immediate options of what to do when you immediately get it are not available. There are some things you can do the day that you get it to return it and refuse to accept it. It's called return or presentment under the Uniform Commercial Code. And by the way, under the Federal Tax Lien Act of 1966, all these extraordinary collection proceedings, like liens and levies, are governed under the Uniform Protection Code. That's the jurisdiction. Not all contracts are under that jurisdiction unless that jurisdiction is written in the contract. A lot of people don't understand that. They think UCC is a universal panacea, another magic bullet. It's not necessarily, but in the case of liens and levies, it does apply. Go to your library, look up your state statutes. It's usually a few volumes, 4, 5, 6 volumes. And you look in the index under Federal Tax Lien Act of 1966, which has been incorporated into the statutes of most states. And you'll actually see what we talked about. You'll see two ways of listing a lien. There's the notice of lien, which is listed in an alphabetical index by the county recorder, and then there is a real lien. A real lien with an affidavit that goes with it, and the elements of a real lien has to have an affidavit, has to have, I don't have the full list in front of me off the top of my head, but there's several elements that it has to have. And it also has to be filed with the Secretary of your state. So what you do is you call the Secretary of your state and you ask, what is the proper procedure for getting a list of all the encumbrances and judgments and liens on file against you? And the Secretary of State will tell you to either write a letter and send in a fee for like $5 or $7 or $9, or they'll ask you to get a UCC-3 form, which is a standardized form under the Uniform Commercial Code. And you'll send that form in, or the letter, and a small fee, and they will send you back a statement of what liens and judgments are on your record at the Secretary of State. And invariably, I will guarantee, in fact, I will take you out to dinner anywhere in the country, if I'm there, or if I can afford to be there at the time. If you get anything back from the Secretary of State, from the IRS, that says you have a lien from the IRS. And the reason for that is there's a lot of reasons for that. But basically, under the law, the IRS is not empowered to actually produce real liens. If you look at 6331, number one, the first thing you'll find out is, if you recall from the earlier show, that a statute has no force of law without a regulation in the Code of Federal Regulations. The statutes are broad authorizing language of the law. That's how they're defined in the law, broad authorizing language. They require regulations written by the Secretary, in this case the Secretary of the Treasury. In the case of transportation statutes, it would be the Secretary of Transportation. They have to write specific regulations to itemize exactly how they're going to enforce those broad authorizations in the statutes. Now, the Secretary, of course, can't write authorizations for anything that would be really unconstitutional, so they don't. Even though the statute might look like it's there, the Secretary has to be more careful about the about the regulations. If you look under the regulations under 6331, which is liens and levies, there are no regulations. In fact, I have a document here. I don't have it in front of me, but if anybody's interested, I'd be happy to provide the citation, or to provide it to you, William, and callers can get it.
Mm-hmm. Well, basically what that means is, if there are no regulations, then there are no liens or levies, and that's why they file notices of liens and not real liens.
That's right. And when you look, they actually had, a couple of years ago, they had a regulation before Congress to actually create a regulation for that, and it was voted down.
Yeah, but at the same time, they're operating fraud, they're creating a fraud, perpetrating a fraud, and they're operating under the color of law, which is a crime in itself, and you can charge them with that crime. And actually, I've seen people take these agents to court who file those liens and sue them and have the liens lifted before they ever got to court, because they don't want it taken into court.
That's right. although you do have to really know the court procedure to do that properly, because people can get into trouble if they do that improperly. Like if you try to file some of the common law liens that patriots have been filing over the last year or so.
No, that's not what I was talking about. I was talking about actually suing an agent of the IRS for leveling a notice of lien on your property and perpetrating a fraud and operating under the color of law.
Right. But be sure when you do that you know what you're doing.
Yes. Oh, well, be sure when you do anything, you know what you're doing.
So a lot of patriots have gotten into trouble by using the wrong kinds of suits in the wrong kinds of jurisdictions, and then the court either throws them out, or some patriots have even gone to jail for frivolous lawsuits. Using 6331 as an example, I'll throw in another interesting legal principle. A lot of people talk about the Internal Revenue Code as being prima facie or non-positive law. And this is an area I just want to clear up, because everybody says, oh, it's not positive law, it's not really law. I don't have to follow it, it's just administrative rules. There's a lot of misunderstanding in the patriot community about what non-positive law is, or prima facie law. But it's a good example, again, of the black and white character of legal understanding and legal principles. Prima facie means on the face of it. The reason there's a lot of Latin terms in the law is because Latin is a dead language. It doesn't change anymore. It's dead.
What it means is it looks like it's an elephant. It's really a duck.
Well, what it means is on the face of it, it means it's law until somebody proves that it's not.
That's what I said.
Well, you see, most people think positive and negative. There's positive law, and that's law. There's law, and then there's things that are not law.
Yeah.
Well, there's this in-between thing called evidence of the laws, or prima facie law, also called non-positive law. Well, it's not just out of the blue sky that they pull this evidence of the law out. The evidence of the law is based on what's commonly referred to as the U.S. statutes at large. The U.S. statutes at large are all the public laws that people vote on in Congress, that Congress votes on, over time. Some of the laws go back to the 1800s. And when they take all the laws and they just put them down in the Federal Register or whatever chronologically, that's the statutes at large. But when they take the laws and they codify them by subject matter, so that we can kind of refer to them easily by subject, they take all the laws that are in the statutes somewhere in the statutes at large, and they put them together in one place, and then they codify it, which means they kind of reword it so that it kind of all fits together properly. Then it becomes a title in the code, like the Internal Revenue Code is Title 26. So Title 26 has never been enacted into law in its own right. They've never taken the title, the 2 books or 4 books, depending on the volume that you have, the set that you have. They've never taken that and voted on it and made it positive law. So Title 26 is only evidence that somewhere in the U.S. statutes at large, there really is a law that was actually passed by Congress. Now, let's use 6331 again, liens and levies, because I want to demonstrate further how phony liens and levies are and how completely... So Title 26 has never been enacted into law in its own right. They've never taken the title, the 2 books or 4 books, depending on the volume that you have, the set that you have. They've never taken that and voted on it and made it positive law. So Title 26 is only evidence that somewhere in the U.S. statutes at large, there really is a law that was actually passed by Congress. Now, let's use 6331 again, liens and levies, because I want to demonstrate further how phony liens and levies are and how completely deceptive and fraudulent this whole system is.
Well, we're gonna have to save that for another night, Bob, because we're just about out of time. I want you to give the information on how they can reach you about your seminar that's coming up in Phoenix, and then I have to do a spot for Swiss American.
Okay, well, just 10 seconds then. 6331 goes way back into the 1800s, 1866 actually, when it was written in a law to collect taxes on distilled spirits, cotton, and tobacco. So it doesn't apply to anybody. Now, I can be reached at Boston Tea Party Enterprises, area code 602-282-5653. My name is Bob Ross, ROSS. My next workshops I'm giving, I give a 2-day workshop, which basically teaches fundamental principles of law, so that you can understand the issues before you go to anybody that's going to give you a system for getting out from under the IRS, or for becoming sovereign, or for becoming a common law citizen or a state citizen, or whatever the system you're interested in. None of those systems provide enough education. You really need to learn the law in an unbiased forum, and that's what I try to provide. The workshop is called What the IRS Doesn't Want You to Know. It's 2 days, and I have 3 scheduled next in the Phoenix area right now. And they're February 19th and 20th is the next one. And I have one in mid-March and one in early April.
Why don't you give your number a couple times again, just for the people who might be slow out there. I tell them always have paper and pen by their side, but there's always a few dummies out there that never listen. So why don't you repeat it a couple more times so if they're running around looking for a pen, they can write down your number again.
Okay, it's area code 602-282-5653. That's Bob Ross, Boston Tea Party Enterprises, 602-282-5653.
Well, thank you, Bob, for all the wonderful information that you've given out tonight on the early show and on this late version of the Hour of the Time, and we'll talk to you later.
Thank you, Willie.
Folks, if you're sitting there listening to all of this, you've been listening to the Hour of the Time for some time, then you know how much you've been scammed, and you know what's coming down the line. People are beginning to wake up across this country, and as they wake up, they're going to create a lot of questions that have to be answered. The answer is going to come in a form that none of us are going to like. I can assure you of that. These people who are bringing about the New World Order have gone too far, too fast, and they have too much to lose to give in to anybody so easily as that. So just asking questions and taking our problems into court ain't gonna get it, folks. There will be no political solution, and there will be no relief in the courts. Relief will come to individuals only, not to the nation, I can assure you. You need to protect yourself against the inevitable consequence of all of this. Call Swiss America Trading now, 1-800-289-2646. That's 1-800-289-2646. As always, don't ever believe anything that you hear on this show or anywhere else unless you have investigated it yourself and can confirm it in point of fact. Listen to everyone, read everything, believe nothing unless you can confirm it in your own research. Good night, and God bless you all.